morning. Welcome to EduSet Network. Friend, as you know, this week we have organized a series of lecture on social work, but today we are not going to discuss the social work, but a very important topic, that is the fundamental right, and especially the Article 21. We have already discussed briefly in the last lecture the fundamental of what is the definition of law, personal liberty, and the procedure set by law, what is the meaning of it today, and also right to free legal aid, right to solitary confinement, right to a speedy trial, and today we'll try to understand the right against handcuffing and third degree punishment. So we'll try to understand this article and the different special of it, and what are the judgment which have come in the different other cases. So through the judgment we'll try to understand this right against handcuffing and the third degree punishment. And for discussion on this very topic, we have in the studio Dr. Rakesh Kumar. He teaches in the Guru Gobind Singh Press University, and he has specialization in this Constitution of India, and he also try to interpret the Constitution of India in the present context and evolve the system that can help to the general masses. So I think his personal experience with dealing with the cases and also the theoretical aspect will give us insight about this article. So on your behalf, I welcome him for the EduSet lecture on this topic. Welcome, sir.
Thank you, sir. Good morning to listeners. In my previous lectures on Article 21, I have given you detailed explanations to the meaning of the terms right to life, the meaning of the term personal liberty, and the meaning of the term procedure established by law, and how by way of sheer judicial creativity, the Indian judiciary has equated the procedure established by law under Article 21 with the due process clause of the US Constitution. And after Menka judgment, the horizons of Article 21 is ever expanding. And in my previous lectures, I have tried to cover some of the important dimensions of Article 21, such as right to free legal aid, right against solitary confinement, and most probably I have given you the brief idea about the right to speedy trial. So in today's lectures, I will continue from the right to speedy trial itself. What I said in the previous class, that the right to speedy trial itself has been accorded one of the integral component of right to life under Article 21 of the Constitution. And so if any procedure which has been prescribed or which has been postulated by the Parliament or by the law, and if that procedures do not ensure fair, just and reasonably quick trial, then definitely in that case it will be violative of the very important rights which has been given to the citizen of this country under Article 21 of the Constitution. So procedures cannot be considered reasonable, fair or just unless it ensure a speedy trial for determinations of the guilt of the persons deprived of his liberty. And this is not something which is unique with the Indian constitutions. You can also find the similar kind of provisions which has been provided by the 6th Amendment to the US Constitutions, which provides that in all criminal prosecutions the accused person shall enjoy the right to speedy and public trial. Apart from this, you also have the Article 3 of the European Conventions on the Human Rights, which provides that everyone arrested or detained shall be entitled to trial within a reasonable time or release pending trial. And this issue was directly taken up by the Supreme Court in Husainara Khatun case. This is a very important case where it was brought to the knowledge of the court that some of the under trial prisoners are languishing in the jail for so many years and they are not being subjected to trial, and this fact was being highlighted by the express newspapers. So in Husainara Khatun 1 versus Home Secretary Bihar in year 1980, Supreme Court said that procedures which keep such a large number of people behind the bar without trial so long cannot possibly be regarded as reasonable, just or fair, so as to in conformity with the requirement of Article 21. Justice Bhagwati, speaking on behalf of the court, said the right to speedy trial is a fundamental right, is implicit in the guarantee of life and personal liberty enshrined in the broad sweep of and content of Article 21 of the Constitution. So no procedure which does not ensure reasonably quick trial can be regarded as reasonable, fair or just procedure. And the same view was also retracted by the Supreme Court in Husainara Khatun second and third case. And right to speedy trial was considered extensively by the Supreme Court in A.R. Antule versus R.S. Naik case in year 1992, where the Supreme Court said the right to speedy trial flow directly from Article 21, and it is available to the accused at all stages, starting from the stage of investigations, inquiry, trial, appeal, revision, and even during the period of retrial. However, in the A.R. Antule case, the Supreme Court has refused to fix any deadline before which the case has to be disposed of by the court. But the court has has given the certain guidelines. What the Supreme Court says that the period of remand and the pre-conviction should be as short as possible. And the second thing, the wrong, anxiety, expenses, and disturbance to his vocations resulting from unduly prolonged investigations or inquiry shall be minimal. And third, undue delay may result in the impairment of the ability of the accused to defend himself, whether on account of the death, disappearance, or non-ability of the witness or otherwise. And fourth, the accused cannot be denied of the right to speedy trial merely on the ground that he has failed to demand a speedy trial. However, the court said that no fixed time limit can be let down as to under which the case has to dispose of. However, in some of the cases like the Raghuveer Singh versus Common Cause and Rajdev Sharma case, where the Supreme Court has gone ahead and Supreme Court has said that if there is a prolonged delay in the disposal of the case, then the accused person will be entitled to release on bail, or even some cases the cases has to be quashed against such accused person. But the Supreme Court, the 7th bench of the Supreme Court in P. Ramchandra Rao versus State of Karnataka case in year 2002 has overruled the Common Cause and Rajdev Sharma case and said that the no fixed time limit has to be let down, and it will depend upon the fact and circumstances of the case, complexity of the case, as well as the tactics which might be adopted by the accused as well as the prosecutions with respect to that particular case. Sometimes it is not merely the right to speedy trial which has been accorded the status of fundamental right under Article 21 of the Constitution. If you see the under Indian working of the Indian judicial system, what is happening today is that sometimes after hearing the argument from both sides, sometimes the court also reserve the judgment, and there is also prolonged delay in the pronouncement of judgment on the part of the judiciary. With respect to this, the Supreme Court itself has clarified that the justice delay is justice denied, but the justice withheld is even worse than that. So Supreme Court has issued a advisory to all the courts that they should make all the sincere effort to pronounce the judgment, and they should not for a long period sit over the judgment. So if the argument has been concluded, and so in that case it is expected that the court must come out with a clear-cut verdict, so that will provide some kind of the solace to the persons whose case is pending before the court. After discussing the right to speedy trial, now I am coming the other important dimensions of Article 21, that is the right against handcuffing. You might have seen your daily experience that whenever the police goes to arrest any person, the moment the person is arrested, he is immediately put under the handcuff. So now the questions will are whether we have any constitutional or legal provisions or statutory provisions which empower the police authority to put a handcuffing invariably in all cases, or handcuffing has to be resorted by the police only in the limited circumstances, only under the exceptional circumstances. This issue was being addressed by the Supreme Court on its war against the prisons reform as well as the protections of the rights of the prisoners in the Prem Shankar versus Delhi administration way back in year 1980, where the validity of the certain clause of the Punjab police rule were challenged on the ground that it is being violative of Article 14, 19 and 21 of the constitutions. What is being provided by the para 26 of the Punjab police rule, that every under trial who is accused of the non-valuable offence punishable with more than 3 years shall invariably be handcuffed. So the constitutionality of this provision was being challenged before the Supreme Court, and in Prem Shankar versus Delhi administration case in year 1980, this case was decided by the Supreme Court, and the judgments were delivered by Justice Krishna Iyer. Here the Justice Krishna Iyer, by delivering the majority judgment, has said that the provisions in the para 26 and 22 that every under trial who was accused of the non-valuable offence punishable with more than 3 years jail term would be handcuffed were violative of Article 14, 19 and 21 of the constitutions. But the you see the approach of the judiciary, what the Supreme Court said in this case, said the Supreme Court that handcuffing should be resorted only in such cases where there is a clear and present danger of escape, breaking out the police control, and for this purpose there must be clear material on records and not merely assumptions. In the special circumstances, the applications of the iron is not ruled out. But even where the extreme cases, handcuffing is to be put on the prisoners, the escorting authority must record simultaneously the reasons for doing so. Otherwise, under Article 21, the procedures would be unfair and bad. Thus, it is implicit in Article 21, which insists upon the fairness, reasonableness, and justice in the procedures for deprivations of life and liberty. So, if the police had decided to resort to handcuffing, then that case there must be clear compelling circumstances that will compel the police to go to that strategy. And if the police had decided to handcuff, then this fact has to be recorded by under what circumstances they have decided to handcuff the accused persons. Invariably in all cases where there is no need of there is no danger of that the accused person will escape the police custody, or they will try to run away, so there is no need. So in that case they cannot go for the handcuffing on the flimsy ground. What the Supreme Krishna Iyer said in this case is that the handcuffing is a prima facie inhuman and therefore unreasonable and over harsh, and at the first flush arbitrary. Absence of the fair procedures and objective monitoring to inflict iron to resort a geological strategy is repugnant to the Article 21 of the Constitution. So now the police is not having any constitutional or legal right to resort to handcuffing in each and every case. They can resort to the handcuffing only in such cases where there is a clear and present danger of escape of the accused persons from the police custody. And if the police has decided to handcuff any persons, then that case police is under the duty bound to record the reasons for doing so. There is another interesting case, that is the Sunil Gupta versus State of MP case. This case was decided by the Supreme Court in year 1990. Here in this case, the petitioner was educated persons and he was a social worker who was remanded to judicial custody, and he was taken to the court from jail and back from the court to the jail by the escort party in the handcuff conditions. And he has staged a dharna for the public cause and voluntarily submitted for themselves for the arrest, and he even refused to come out on the bail for the public cause. So the step which was taken by the police regarding the resorting of the handcuffing was being challenged before the Supreme Court in Sunil Gupta case, where the Supreme Court said that the act of the escort party was clearly violative of Article 21 of the Constitution, and there was no reasons recorded by the escort party in writing for such inhuman act. What the court said that the court has directed the government to take appropriate actions against such a deviant escort party for having unjustly and unreasonably handcuffed the prisoners, because in that case he voluntarily submitted himself to the judicial to the police, and he was sent to the judicial custody when he was not willing to go out on the bail. So what was the necessity for the police to go for the such handcuffing? So in this case here the Supreme Court has directed that the necessary action should be taken against the such deviating escort party. Again, the Citizens for Democracy State of Assam case, where the Supreme Court has said that the handcuffing and in addition to the tying of with ropes of the patient prisoners who are lodged in the hospital is inhuman, and it is violative of the human rights guaranteed to the individuals under international as well as the law of the land. Where the person is arrested by the police without warrant and the police officer is satisfied on the basis of the guidelines laid down the Prem Shankar case that it is necessary to handcuff such a person, then he may do so till the time he is taken to the police stations, and thereafter he can only be under the order of magistrate. So once he has been produced before the magistrate, and if the magistrate has given the direction that he should be handcuffed or he should be put in particular conditions, then only the police can do so. Here the police cannot, after producing the accused persons to the magistrate, he cannot go for handcuffing. If he want to do so, then in that case he has to take a prior permissions from the magistrate before doing so. And what happened in this case, Citizens for Democracy State of Assam case, here it's not only that the patient prisoners was handcuffed, he was also tied with the rope. You see the how such a barbaric practice was being resorted by the police, which was against the constitutional provisions, which was against the mandate of the Article 21, which invariably insists upon the just, fair and reasonable procedures. Now I am coming to the other important things regarding the right against inhuman treatment and third degree method, because you might have heard about the police invariably resort to the third degree treatment just to extract the confessions from the persons accused of the commission of the crime. This issue was being tried to address by the Supreme Court in Kisori Singh versus State of Rajasthan case in year 1981, where the Supreme Court has said that the use of the third degree method by the police is violative of Article 21, and directed the government to take a necessary step to educate the police so as to inculcate a respect for the human rights. And the court has also said the punishment of the solitary confinement for the long period of 8 to 11 months, putting a bar fetters on the prisoners in jail for several days on the flimsy grounds, like the loitering in the persons, and in a behaving uncivilized manners, tearing in the history ticket, must be regarded as a barbarous and against the human dignity, and hence it should be considered as violative of Article 14, 19 as well as Article 21 of the Constitution. In Kisori Singh case, what the Justice Krishna here said that the human dignity is the clear value in our constitutions, not to be bartered away by mere apprehensions entertained by the jail officials. So in this case, the third degree method which is resorted by the police was clearly negated by the Supreme Court in Kisori Singh case. Again in Sheela Barsi versus State of Maharashtra case in year 1983, where the Supreme Court held that the tortures and ill treatment of the women suspect in the police lockup is a violative of Article 21 of the Constitution. Here in this case, the court gave a detailed instructions to the concerned authority for providing security and safety in a police lockup, and particularly to the women suspect. And what the Supreme Court said in this case is that the female suspect should be kept in a separate police lockup and not in the same room where the male accused are detained, and should be guarded by the female constable. And court has also directed to the IG prisons as well as the State Board of the Legal Advisory Committee to provide legal assistance to the poor and indigent accused, whether they are under trial or convicted prisoners. So the Supreme Court has taken a very decisive step in Kisori Singh as well as in the Sheela Barsi case, just to protect the citizens against the inhuman treatment which is being provided by police in the lockup without any kind of the judicial sanctions or judicial approvals. After the right against inhuman treatment, again I am moving to the other important dimensions of Article 21 of the Constitution, that is the protections against illegal arrest, detentions and custodial death. If you see the approach of the Supreme Court has occasions to examine the meaning of the, just to provide protections to the citizens as well as non-citizens under Article 21 of the Constitution against the illegal arrest and detentions which is being carried out by the police. Here in the Joginder Kumar State of UP case, the Supreme Court has laid down the detailed guidelines governing the arrest of the persons during investigations to strike a balance between the needs of the police in one hand and the protections of human right of the citizens from oppressions and injustice in the hands of law enforcing agency. Because whatever the guidelines which was given by the Supreme Court, it is pertinent not only for the students but also for the members of general public, because if the police are coming to arrest, then that case the person must be aware what the right they have, what the duty they have, and once they are aware of those rights, then in that case, instead of the voluntarily submitting to the each and every dictates of the police, they can insist upon that these right to be protected, these right to be safeguarded. Here what the Supreme Court in Joginder Kumar case said that the person is not liable to arrest merely on the suspicions of the complicity of the offence. there must be a reasonable justifications in the opinion of the police officers effecting an arrest that such arrest was necessary and justified. So if the police has come to arrest a person, then that person has every right to demand or to sought explanation from the police as to whether you have any reasonable justifications to ensure or effectuate the arrest. Second, an arrested persons being held in custody is entitled to, if he so requests, to have one friend, relatives or other person who is known to him or likely to have an interest in his welfare told as far as practicable that he has been arrested and where he is being detained. So it is not only that you have the right to demand that on what ground you are arresting me. That things you can simply ask from the police. As the police has given you justification, here the sufficiency of the justification which will be provided by the police, that is not relevant. But because the police, anyhow police has to justify such arrest before the court, and it has to prove beyond the reasonable doubt in criminal cases. But the second thing is that if the police has decided to arrest you, then that case you can insist that the factum of the arrest should be informed to any of his friends, relatives or anybody who is interested in their welfare. And third thing, which the Supreme Court said in this case, that the police officer shall inform the arrested persons when he is brought to the police station about this right. So here you can demand from the police, and the police is also under constitutional as well as the legal obligations to record in writing as to which of the person is being informed about the arrest of such persons. So entry shall be required to be made in the diary as to who has been informed about the arrest of such persons. So this is a very important guidelines which was given by the Supreme Court in Joginder Kumar v. State of UP case in year 1994. Again in Neelbati Behera v. State of Odisha case in year 1997, where the Supreme Court has awarded compensation of rupees 1,50,000 to the mother of the deceased who died in the police custody due to the beating by the police. And if you see the police version was that the accused has escaped from the police custody at about 3 a.m. by chewing off the rope, and thereafter his body was found on the railway track. But the evidence and the medical report has proven otherwise. So in that case, it was being proved beyond doubt that the death of the person is being caused not because of the escape, but it's only because the beating by the police officers. In that case, police was held liable, and state was asked to pay compensation of rupees 1,50,000 in Neelbati Behera case. Again, Supreme Court has put a new projectiles in the DK Basu versus State of West Bengal case, where the Supreme Court has given the detailed guidelines that has to be followed by all the investigating and the security agency in all cases of the arrest and detentions. Here the Dr. Justice Anand, while delivering the judgment of the court, said that any form of the tortures, cruels or inhuman or degrading treatment would fall within the inhibitions of Article 21 of the Constitution, whether it occurs during the investigations, interrogations or otherwise. He further said the custodial death is perhaps one of the worst crime in a civilized society governed by the rule of law. So just to protect the persons from the illegal arrest and detentions as well as from the custodial death, here the Supreme Court in DK Basu case has given the detailed guidelines. I am coming to some of the important guidelines. The first was that the police personnel carrying out the arrest and handling of the interrogations of the arrest should bear accurate, visible and clear identifications and name tags with their designations, and these particulars of all such police personnel must be recorded in register. So first thing with the Supreme Court in DK Basu said that if the police is going to arrest any persons, then that case the police personnel must disclose their identity. They are required to disclose their identity to such persons, as well as they are also required to bear the nameplate where they will have the accurate, visible and clear identification. Their name should be clearly mentioned there along with their designations. The second thing, the police officers carrying out the arrest of the person shall prepare a memo of arrest at the time of arrest, and such memo must be attested by at least one witness who may be either family members of the arrestee or respectable persons of the locality. So it is not you are disclosing that who is the person who is arresting you. Second thing, that you are required to prepare a memo of arrest. In memo of arrest, that has to be signed by either the family member of the arrested persons, or it may be signed by any other respectable members of that locality or that place where the arrest is being effected by the police. The third thing, which the Supreme Court in this case said, that the person who has been arrested or detained shall be entitled to have one friends or relatives or other persons known to him or having interest in his welfare informed as early as possible. And the fourth thing, with the Supreme Court in D.K. Basu case said that the time, place of arrest, venue of the custody of the arrestee must be notified by the police where the next friend or relative of the arrestee live outside the district or town through the legal aid organizations in the district, and the police stations of the area concerns telegraphically within the period of 8 to 12 hours after the arrest. So time, place of arrest and the venue of detentions, everything has to be recorded by the police in the register, and police is also under legal obligations to record as to who is being informed about the arrest of such persons. And the fifth thing, with the Supreme Court in D.K. Basu case said that the arrested persons must be aware of this right to have someone informed of his arrest and detention as soon as he is put under the arrest or detentions, and all these must be entered into a diary. And apart from this, the arrestee should where he so request be also examined at the time of arrest of all the major and minor injury, if any, present in on his or her body, and it must be recorded at that time. So moment the police are making arrest, police is if the arrested person wants, then they can also get it recorded whether any kind of the injury was present at the time of arrest or not, because this recording is very vital, because it is something which will act as a effective deterrent against the police by resorting the third degree method, because any case after arrest the person has to be produced before the magistrate within the 24 hours of his arrest. And if during this period after the arrest and the moment he is being produced before magistrate, if there is any visible sign of any kind of the injury, then that case it can safely presume that such injury has incurred because of the beating or the tortures which might have been inflicted upon such arrested persons by the police. The court further said the inspection memo must be signed by both by the arrestee as well as by the police officers effecting the arrest, and its copy must be provided to the arrestee. The fifth thing, with the Supreme Court said the person should be subjected to the medical examinations by the trained doctors within 48 hours. Next, the copy of all the documents including the memo of arrest should be sent to the area magistrate for his record. The next guidelines was the arrestee must be permitted to meet his lawyers during interrogations, though not throughout the interrogations, and the police control room should be provided at all the district and state headquarters the informations regarding the arrest and place of detentions. So this was a very significant pronouncement by the Supreme Court in D.K. Basu case, where the Supreme Court has laid down the detailed guidelines which has to be followed by the police when they are effecting arrest. They have to prepare arrest memo, they have to get a signatures from any respectable persons of that locality or relative of the person arrested, and they are also required to inform to the relatives or friends of the persons. They are also required to notify the place where the such person has been detained, and the most importantly, the person is also required to they have the right to record right to get it recorded about any kind of injury which he has suffered at the time of arrest. So if any kind of injury is there, so it has to be recorded, and anyhow he has to be subject to medical examinations within 48 hours after arrest. So this was very significant judgment on the part of Supreme Court, where the Supreme Court has taken a very definite measures to protect the persons against the inhuman treatment or third degree treatments, as well as to prevent any kind of the illegal arrest or detentions, as well as protect the persons from the custodial death which might be inflicted upon him in the police custody. Now I'm coming to the other important dimensions of Article 21 of the Constitution. Suppose the person is being arrested, and if later on it is found that the such arrest was not justified, it was illegal, then that case whether the state will be entitled to claim the sovereign immunity, or the state can claim that they should be immune from any kind of the compensations or the obligations to pay compensations to persons whose right to life and personal liberty are being infringed by the such police actions. Here, with respect to the, if any such arrest or detention is being made by the police and later on if it is found to be legal, then that case here the state cannot take the plea of the sovereign immunity, and the principle of strict liability shall be applicable in such case, and this government or state will be under obligations to compensate for such illegal arrest or detention which is being carried out by it. And regarding the if any person has died because of the custodial death or custodial violence, then that case here the such persons will be entitled to claim appropriate compensations from the state. And the court has also reiterated the view that the sometimes monetary or the pecuniary compensations is more appropriate and indeed a more effective remedy for the redressals of the such wrong which is being caused to the persons because of the illegal arrest which was carried out by the police personnel. And in such cases police cannot take the plea of the vicarious liability, and the principle of strict liability will be applicable, and the state will be liable to compensate for the wrongdoing of their officers. I'm taking the first case. This is a very important case of Rudal Shah versus State of Bihar. Here in this case, the accused persons he was discharged by the police and he was ordered to be released. And after the passing of the order by the court, he was allowed to remain in jail for 14 years because of the sheer negligence on the part of the jail authority. So, and this fact was brought to the notice of the court by the public interest litigations, where the Supreme Court has directed the government of Bihar to pay compensation rupees 30,000 to Rudal Shah, who had remained in jail for the 14 years because of the irresponsible behavior of the state government even after his acquittals. Again, you have the very interesting case of Bhim Singh versus State of J&K. This case was decided by the Supreme Court in 1985. Bhim Singh, he was an MLA of the Panther Party in the state of J&K, and when he was going to attend the assembly session, he was illegally detained by the police, and he filed a writ petitions before the Supreme Court. And in this case, the Supreme Court has awarded a sum of rupees 50,000 to the Bhim Singh for violations of his constitutional right of the personal liberty by the illegal detentions by the police officers. So, if any person is being illegally detained, and if it is proved that the such detention was not justified, it is not having the backing of the law, then that case police personnel effectuating such arrest will be liable to pay compensations for such act. Again, you have the very interesting case of the PUDR versus Police Commissioner Delhi, where the Supreme Court has awarded a compensation of rupees 75,000 to the laborers who was died due to the beating by the police on demanding the wages after doing work in the police headquarters. What happened in this case is that after working in the police headquarters, when they demanded the wages, then the police has resorted beating to such persons. And this fact was brought to the knowledge of the court by the People Union of the Democratic Right through the public interest litigations, and the Supreme Court has awarded compensation of rupees 75,000 in such case. Again, you have the case of Saheli versus Commissioner of Police. This case was decided by the Supreme Court in year 1990, where the Supreme Court has directed the Delhi administrations to pay rupees 75,000 as a exemplary compensations to the mother of 9-year-old child who died due to the beating by the police officers. Again, in the state of Maharashtra versus Ravikant Patil case in year 1991, where the Bombay High Court held that the handcuffing and the parading of the petitioners on the or as being the suspect of the murder was unwarranted and violative of Article 21 of the Constitutions, and the Supreme Court has directed the Inspector General of Police to pay compensation rupees 10,000. And apart from this, what the significant things which the Supreme Court did in the state of Maharashtra versus Ravikant S. Patil case is that the Supreme Court has ordered that this fact is to be recorded in the service record of such police personnel who, after handcuffing the accused person, has also paraded him in the entire village. If the person is being detained, definitely in that case he has to be taken in custody. But here the police cannot resort the means of just to moving around that person, because at that point he is merely accused of the commission of the crime, and it is only after his guilt is being proved, then that case he will be awarded the appropriate punishment by the court. He cannot be subject to punishment in the form of moving such persons throughout the village by the police personnel. Here the police cannot assume the role of judiciary. Again, I am taking the case of the People Union for the Civil Liberty, where the Supreme Court has held that the killing of the two persons, the fake encounter by the police, was a clear violative of the right to life guaranteed by Article 21 of the Constitutions, and the defense of the sovereign immunity does not apply in such case. Here in PUCL versus Union of India case, here the Supreme Court has followed the guidelines which was given by the Supreme Court in Nilbati Behera versus State of Odisha case, where the Supreme Court has quoted with approval the provisions of Article 9 Clause 5 of the International Covenant on Civil and Political Right in 1966, which says that anyone who have been victim of the unlawful arrest or detention shall have an enforceable right to compensation for enforcing their fundamental rights. So if anybody has been subjected to such kind of atrocity by the police personnel, then that case such person will be justified to claim appropriate compensations from the atrocity which might have been committed by the police personnel in the discharge of their executive powers. Now we come to the other important case. This is Delhi Domestic Working Women's Forum versus Union of India case. This case was decided near 1995. Here, this case, the petitioners through the public interest litigations brought to the pathetic conditions of the 4 domestic servants who were raped by the 7 army personnel in a running train. Here the court has expressed the serious concern about the increase of the crime against the women in recent times, and suggested that the defect in the criminal law should be removed, and the appropriate measure must be taken by the government to check the crime against the women. But in this case is important for our purpose, because in this case Supreme Court had laid down the certain guidelines that has to be followed for the trial of the rape victims. Here the Supreme Court said the complaint of the sexual assault should be provided with the legal representations. The victim advocate role should be explained to her. Second, the legal assistance will have to be provided at the police stations, since the victim of sexual assault might be in very distressed stage at the police stations. So the guidance and support of the lawyer at this stage would be a great help to her. The third thing which the Supreme Court said in this case, that the police should also be under a duty to inform the victims of her right to be representations before any questions is being put, because in such cases it is also very important that the such persons must be subjected to medical examinations at the earliest moment, and they are already in distress conditions. So what the Supreme Court said that every police station must be provided with the list of advocates who are willing to work in such cases, and they must be provided appropriate kind of the counseling. And it is only after the providing appropriate kind of counseling, such person should be subjected to some kind of the initial questioning, so that the police will elicit the more informations to apprehend the accused of such crime. But one thing which the Supreme Court has said in this case, that the every effort should be made by the police that to complete anonymity has to be maintained regarding the names of the victims, and the name of the victim should not be disclosed under any circumstances. And here the court has also emphasized that the Criminal Injury Compensation Board has to be established, where the appropriate compensations to be provided to the all such victims who have been subject to such kind of the unfortunate assault. Again, in Bodhisattva Gautam versus State of versus Subra Chakrabarti case in year 1996, here the Supreme Court has awarded an interim compensation of rupees 1,000 per month to the victims of the rape until her charges of rape are decided by the trial court. Here the Justice Sagir Ahmed, who has delivered this judgment, here he has highlighted some of the very unfortunate things which our society is facing, and what they have stressed while delivering the judgment is that here in this case, though constitutionally women are enjoying the equal status along with their counterparts male, but because of the our social conditions, they are subject to various kind of the social barriers, and they are subject to various kind of discriminations. So every effort should be made so the fellow men will learn they will inculcate the value to how to respect the women, and if you start respecting the women from your household itself, then only in that case you will be able to sensitize the society at large, and it is only sensitization of society at large you will be able to check the all the kind of the violence which are being committed against women, because role of police will start only once the crime is being committed. Here the police cannot anticipate something, and the police will take a, if they are having some kind of information, definitely in that case police will take a definite positive step in that direction to check the crime. But what is necessary to check the crime against women, that the society at large must be sensitized. They must inculcate the basic civilized value, which are something which is very crucial to our society, to our civilizations, and it is only after such educations, such inculcations of the civilized norms, we will able to eradicate all kind of the violence which are being committed against the women. After discussing some of the important dimensions of Article 21, now coming to some of the other dimensions. The first thing that regarding the practice which is generally being followed, that the under trial person is also being kept along with the convicted persons. Here, what the Supreme Court in Sunil Batra versus Delhi administration case has said, that the under trial should be kept in a separate room from the convict and the hardened criminal whose guilt has been proved beyond a reasonable doubt. So this is a very important pronouncement by the Supreme Court in the Sunil Batra versus Delhi administration case, where the Supreme Court has said that in any case the under trial should not be kept along with the convicted persons. And if you see the Sunil Batra case, then one of the very important remarks which was given by the Justice Krishna Iyer while delivering the judgment, he said that the integrity of the physical persons and his mental personality are an important right of the prisoners, and it must be protected from all kind of the atrocities. Here in the Sunil Batra 2 versus Delhi administration case, the Supreme Court has laid down the detailed guidelines. What the Supreme Court has said, that the petitioner Sunil Batra, he was subjected to tortures by the jail authority just to extract the wages which he has earned from doing the work inside the jail premises. And what the Supreme Court said, that the tortures which was inflicted on the petitioners was illegal, and he shall not be subjected to any such tortures until fair procedures is complied with. And second, the Supreme Court says that no corporal punishment or personal violence shall be inflicted on the persons who are inside the jails. And the most important thing which the Supreme Court said in this case is that the lawyers nominated by the district magistrate, session judge, high court, as well as the Supreme Court, they will be given all the facility to interview, including the right to confidential communications with the prisoners, subject to discipline, the security considerations, and lawyers shall make a periodical visit and report to the concerned court about the result of such visit. Here, apart from this, here the Sunil Batra case, the Supreme Court has also directed to all the jail authority throughout the country that the grievances deposit box is to be installed in all inside the jail premises, and it shall be opened by the district magistrate, session judge, who will frequently visit the jail, and all the prisoners must have access to such grievances deposit box. And some of the most important things which the Supreme Court said in Sunil Batra case, that no solitary or punitive cells, no hard labor or dilatory charge, denial of the privilege and amenities, and no transfer to other prisons as a punishment shall be imposed without the judicial approval. So in this case, just to protect the persons who were inside the jails against the atrocity of the jail authority, here what is provided, the grievances deposit box that has to be opened by the district magistrate or session judge. So if anybody is being subjected to any such kind of violence, then they can simply put a postcard or simply drop a letters in that grievance deposit box, and the fact of the tortures to which he is being subjected to, it will come to the notice of the court, and the court will take appropriate actions against such persons. Then I am coming to the other important things regarding that, the death by hanging. As to when any person is subject to the capital punishment, then that case the person after the awarding the capital punishment, he is the capital punishment is being executed by hanging by rope. So the practice of hanging by rope was being challenged before the Supreme Court in the Dina versus Union of India case in 1983, and it was being contended before the court that the procedures which was being prescribed under section 354 clause 5 of the CRPC is unreasonable, and it is being violative of Article 21 of the Constitution. So in crux, the issue before the Supreme Court was as to hanging by rope is a something which can be characterized as a barbarous act, or it is something which will come within the purview of the due process which is being provided under Article 21 of the Constitution. Here in the Supreme Court, before deciding this case, has decided to take a help from the report of the UK Royal Commissions on 1949, and apart from this, they also sought the opinion of the Director General of the Health Service of India, and they have considered the 35th report of the Law Commissions, and they have also sought the opinion of the prisons advisors as well as the forensic medical expert. And after considering the views of all such persons, here the court has concluded that the section 354 clause 5 of the CRPC, which prescribed that hanging as a mode of executions lays down the fair, just and reasonable procedures, being the meaning of Article 21 of the Constitution, and it is constitutional. Here, after considering all this report, where the court has said that the hanging by rope is the best and the least painful method of carrying out the death sentence than any other methods which might be resorted. Here the court has declared that neither the electrocutions nor a lethal gas or shooting nor even the lethal injections has any distinct advantage over the system of hanging by rope. So hanging by rope is being upheld by the Supreme Court in Dina versus Union of India case, and it is held to be constitutional and in as per the fair, just and reasonable procedures as being mandated by Article 21 of the Constitution. Then other issue which has agitated the mind of the court regarding that if somebody is being subject to the capital punishment, but in that case where the court will have any power that they can order for the public hanging. Here because this case was being considered Supreme Court's Attorney General of India versus Lakshma Devi case in year 1986, where after abolisting the capital punishment, here the court has ordered that the person should be hanged in the public places. Here the court says that the executions of death sentence by public hanging is a barbaric and is a violative of Article 21 of the Constitution. And what the court has said in this case that it is true that the crime of which the accused has been found guilty is a barbaric, but barbaric crime does not have to be visited with a barbaric penalty such as public hanging. So public executions of capital punishment by public hanging is being disapproved by the Supreme Court in Lakshma Devi case, and here the court has directed to take appropriate actions against the concerned authorities who had executed the death sentence by public hanging. Now we come to the other important dimensions, the right against the delayed executions, because if the person is being subject to the capital punishment and if there is an undue delay on the part of the police to execute the death sentence, or if he has filed the mercy petitions before the executives and if that mercy petition is still pending before the police, but in that case whether any such right will ensue in favor of the such persons who is being subjected to the capital punishment. Here, this issue was being considered by the Supreme Court in TV Batheswaran versus State of Tamil Nadu case in year 1983, where the two-judge bench of the Supreme Court has held that delay in executions of death sentence exceeding 2 years would be sufficient ground to invoke the protections of Article 21, and death sentence would be commuted to the life imprisonment. So, in way back in year 1981, here the Supreme Court has, if there is a prolonged delay in executions of death sentence, then that case the accused persons or convicted persons can approach the court and they can demand that the death sentence should be converted into life imprisonments. Again, this issue was considered by the Supreme Court in Sher Singh versus State of Punjab in year 1983, and this case was being decided by the three-judge bench of the Supreme Court, where the Supreme Court said that the prolonged delay in execution of death sentence was an important consideration for invoking Article 21 for judging whether the sentence should be allowed to be executed or should be converted into life imprisonments. Court has also pointed out that prolonged detentions to await the executions of sentence of death is unjust, unfair and unreasonable procedures, and the only way to undo the wrong is to quash the death sentence. However, the court has ruled that this cannot be applied as a rule in every case, and each case should be decided in its own facts. Court has because before taking such a decisive step regarding the conversions of death sentence to life imprisonment, here the court should consider whether the delay was due to the conduct of the convict, or it was because of the nature of the offence, or it was because of his impact on the society, or its likelihood of reputations. So all these factors has to be considered by the court before deciding to convert the death sentence into life imprisonment. However, in this case, here the court has said that the delay was being caused not because of the anything which was being carried by the prosecution, but it was because of the tactics which was being adopted by the lawyers of the convict. So in this case, the court has refused to convert the death sentence to life imprisonment, and the court has also overruled the Batheswaran case, where the Supreme Court has said if there is a prolonged delay of the 2 years, then that case the convicted persons will be entitled to approach the court for convergence of his death sentence into life imprisonment. However, the Supreme Court again take a U-turns in Javed Ahmad versus State of Maharashtra case in 1985, where the Supreme Court said where there is a delay in the executions of death sentence for more than 2 years, and the conduct and the behavior of the accused in jail is evident from the report of the jail authority, shows that they was showing a genuine repentance, then death sentence should be commuted to life imprisonments. So again, after the Sher Singh case, the Supreme Court has taken the U-turn Javed Ahmad case. Finally, all the issue was put to rest in Triveni Ben versus State of Gujarat case in year 1989, where the 5-judge bench of the Supreme Court has overruled all its earlier judgment and said that the undue delay in executions of death sentence will entitle the condemned prisoners to approach the court for convergence of death sentence into life imprisonment. But before doing so, the court will examine the nature of the delay and circumstances of the case. Court has clearly stated in this case that the no fixed period of delay could be held to make a sentence of death inexecutable. So whether death sentence to be converted to life imprisonment or not, it is something which has to be decided on case to case basis by the court by considering all the attendant circumstances. But no fixed time limit can be laid down in for that will be applicable in each and every cases, and mere lapse of that time will something which will empower the convicted persons to approach the court for commutations of their death sentence into life imprisonments. Now coming to the constitutionality of death sentence itself, as to whether the practice of awarding the capital punishment or death sentence, which can be considered as just, fair and reasonable procedures under Article 21 of the Constitution. Here, this issue has directly arisen before the Supreme Court in Jagmohan Singh versus State of UP case in year 1973, and this is one of the very important pronouncement of the Supreme Court, where the petitioner has challenged the validity of the death sentence on the ground that it is violative of Article 19 and 21 because it did not provide any procedures. It was further contended that the procedure prescribed under the CRPC was confined only to the finding of the guilt and not awarding the death sentence. Here the 5-judge bench of the Supreme Court held that the choice of awarding death sentence is done in accordance with the procedure established by law. The judges make a choice between the capital sentence or imprisonment of life on the basis of the circumstances and facts and nature of the case brought and on record before the trial. So death sentence is not being violative of Article 14, 19 and 21 of the Constitutions. But the Supreme Court again take a U-turn in Rajendra Prasad versus State of UP case, where the Justice Krishna Iyer said that the capital punishment would not be justified unless it was shown that the criminal was dangerous to society. He said that giving discretion to judge to make a choice of death sentence and life imprisonments on the special regions under section 354 clause 3 of the CRPC would be violative of Article 14 because which condemns the arbitrariness, because here the discretion has been given to the magistrate, to the judges to decide as to what kind of punishment to be accorded to the persons whose guilt is being proved beyond reasonable doubt. Justice Krishna and Rajendra case has pleaded for the abolition of death penalty, and they have argued for the retentions of death penalty only in the white collar offence. However, the Justice Sen has dissented and they expressed the view that this is a matter that has to be decided by the Parliament, not by the judiciary. Whether the death penalty is to be abolished or not, it is something which the Parliament has to consider. Again, in Bachchan Singh v. State of Punjab in year 1980, the Supreme Court by majority of 4:1, Justice Bhagwati has expressed their dissenting opinion because he was on the same page like the Justice Krishna Iyer, where he was invariably in the view of regarding the abolitions of death penalty. Here in Bachchan Singh case, the Supreme Court has overruled the Rajendra Prasad case and held that the provisions of death penalty under section 302 of IPC as alternative punishment for murder is not violative of Article 21. Article 21 of the Constitution recognizes right of a state to deprive a person his life and personal liberty in accordance with the fair, just and reasonable procedure established by law. So this is the finally in the Machi Singh, Babu Singh and Kashmira Singh case also, where the Supreme Court has upheld that the death sentence is not violative of Article 21 of the Constitution, and all these cases are merely the reflections of the debate which is going on regarding the abolitions of death sentence as well as the retentions of the death sentence. Those who belongs from the deterrent school, they are in the view that the death punishment should retain in the statute, but those who belongs from the reformative school, they are in the view that the death punishment, like the other European country, should also be abolished in India. Apart from this, we also had some other important dimensions of the right to life. I think we will not able to take up the details, but I am just giving you the glimpse of that because after Menka judgment, the Article 21 was subject to rich judicial interpretations and various other right is being read along with the Article 21 of the Constitutions, and one of the important was right to livelihood. In Olga Teli case, where the Supreme Court has read right to livelihood as an integral component of right to life under Article 21 of the Constitutions. However, in the Sudan Singh case, where the Supreme Court said though the right to livelihood something which is postulated by the directive principle of state policy, and it cannot be equated with fundamental right, or cannot be accorded the status of fundamental right under Article 21 of the Constitutions. But in Sudan Singh case, Supreme Court has distinguished this case with the Olga Teli case, where that case pertains to the pavement dwellers who were doing the business on the pavement. So the Bombay Municipal Corporation is directed to ensure the evictions of such persons only after the expirations of monsoon. Again, in Delhi Development Horticulture Employee Union, the Supreme Court has said that the right to livelihood is a very integral component of right to life. Apart from this, in Chameli case, right to shelter was being recognized as an important component of right to life. Along with it, you also have the right to privacy. R. Rajgopal case, I have already taken up in the previous class. And in the state of Maharashtra, Madhukar Narayan case, where the Supreme Court said that the right to privacy is also available even to the women of easy virtue. And the some other things which pertains to Article 20 like the telephone tapping, because in PUC versus Union of India case, the Supreme Court has given detailed guidelines which has to be followed in case if the government has decided to go for the tapping of the phone. In that case, what is being said by the Supreme Court, that the order has to be issued by the persons who are the rank of the secretary, or that power has to be delegated to the at the offices of the joint secretary rank. And advisory board has to be constituted, and all the intercepted communication has to be forwarded to such advisory board. I think when I will have the time, then next class I will try to take up this case.
Okay. So, well friend, today we conclude lecture with these things, and I thank all of you for watching the lecture, and on behalf I thank Dr. Rakesh Kumar for giving such a wonderful lecture on this very topic on Article 21, and especially about right against handcuffing. So I again thank all of you for watching the lecture. Thank you very much.